Madam Speaker, this fourth of House of Assembly is recalled today in accordance with Section 85 of the Virgin Islands Constitution Order 2007. Section 85 states, if between a dissolution of the House of Assembly and the next ensuing general election, an emergency arises of such in nature that, in the opinion of the governor, it is necessary for the House to be recalled, the governor may, acting after consultation with the Premier, summon the House that has been dissolved, and that House shall thereupon be deemed not to have been dissolved, but shall be deemed to be dissolved on the day on which the next ensuing general election is held. I again want to reassure the public, following consultation with the governor and advice from the Attorney General, that the scheduled general election on 24th April will proceed as planned. For the avoidance of doubt, let me be completely clear that this recall of the House is not tantamount to the suspension of our Constitution. It is in fact part of the functioning of the Constitution. It's also important to be aware that in other places such as the United Kingdom, which is the model of the Westminster system of government, the UK Parliament has been recalled at least 34 times since 1948. So the recall of a legislator to address an emergency is not an uncommon thing, although unprecedented in the Virgin Islands. I know that many persons in the community are anxious about what will happen today, because we have never had a situation where the House of Assembly was recalled after its dissolution. However, it is with very good reason that the governor and the premier agreed that it was absolutely necessary and appropriate to do so. We must ensure that the 688 members of our community who have lived, worked, and contributed to our society are not disenfranchised for no fault of their own, and are provided with certainty about their immigration status. We must also ensure the results of the upcoming election are not left open to challenge, which would be the case if we do not act now. Democracy is a sacred trust. We all have a responsibility to protect and uphold it. Democracy provides the legitimacy on which government rests. The rule of law is the best way to ensure that we can participate in an orderly and meaningful way in a democracy. Madam Speaker, it is on the advice of the Honorable Attorney General that we are taking this approach of validating the residence and belanger certificates of the 688 persons who were simultaneously granted residence and belanger certificates under the Fast Track Residency and Belanger program. The Cabinet was initially legally advised that these persons qualified who were then approved. The Attorney General has recently advised that this initial advice was not correct. Madam Speaker, I will elaborate further along in this statement. Madam Speaker, it is important that we have a full appreciation of the background of the Fast Track program. In 1945 and 1946, the population of the Virgin Islands was under 7,000 people. With the development and expansion of our economy, the population has increased by 500%, primarily immigration. These men and women who have come to the BVI primarily to work, and our system allows for these persons to gain status if they meet the minimum requirement of the Immigration and Passport Act. Madam Speaker, for various reasons, the system of granting belongership has been inefficient. Administrative inefficiency is one factor, but also a lack of coherent policy that supports the law has led to huge backlogs. For instance, the policy of a 25% annual quota for residents was instituted by a previous government despite the fact that hundreds of persons would become eligible every year. This would obviously lead to a huge backlog. Various governments over the years have had to implement fast-track programs to assist in clearing the backlog. In 2019, the fast-track residency and belonger program was initiated to grant eligible individuals belonger status. Many persons who have made great contributions to our society applied and were granted the status. Of course, the program generated a great deal of debate, and rightfully so, because immigration in itself is a sensitive topic. Notably, an audit of the Fast Track program was included as one of the actions to be completed in the reform process set out in the framework for implementation of the COI report, recommendations, and other reforms. The audit was completed by the Auditor General, and the report brought to the attention of the Premier on 9th March. The initial report identified 64 persons who did not qualify based on the 20-year requirement for the Fast Track program. However, he asked for this report to be reconsidered based on the incorrect premise that the conclusions in the report were based on. Madam Speaker, I'll elaborate further. The Immigration and Passport Act allows Cabinet to grant belonger status based on 4 different sections. There is a section 16.3, which requires you to be ordinarily resident for 10 years and have a residence certificate for at least 12 months, among other criteria. There is section 16.4 that only requires a person to be ordinarily resident for a minimum of 7 years. This section does not mention a residency certificate. There is also section 16.5 that allows for Cabinet to grant belonger status to someone who has made economic and social contributions and has been ordinarily resident for 50 years. This was amended to 20 years in 2019 for a brief period. This section also does not mention a residency certificate. Cabinet can also grant belonger status to persons who has been married to a belonger for 5 years. Madam Speaker, the Auditor General's initial report assumed that the belonger status granted in the Fast Track program was based on section 16.5 of the Act, where you have to be ordinarily resident for 20 years. Based on that assumption, the Auditor General came to the conclusion that 64 persons should not have gotten belonger status. However, this was not correct because all the Fast Track applications were approved based on section 16.4 that states a person has to be ordinarily resident for 7 years. Madam Speaker, I pointed that fact out because When the audit report came to Cabinet and a legal opinion was requested that would be provided to the Auditor General, a legal opinion was subsequently provided to the Auditor General that resulted in an addendum being attached to the original report to correct this misreading of the law. What the addendum also revealed is that the Attorney General's chambers discovered something that they overlooked when their initial legal advice was provided under the leadership of the former Attorney General. In the law, the definition of ordinarily resident included being free from immigration control for at least 12 months prior to making the application. This can be found in section 16(9)(c). Based on this fact, individuals should not have been granted residence and belonging status at the same time. The Attorney General Chambers, however, advised that Cabinet could proceed with approvals. This was a serious oversight on their part. This is why the Auditor General in her addendum to the Fast Track Audit Report says significant issues of law and applications were overlooked. Madam Speaker, as everyone in this House knows, for Cabinet to make a decision, advice has to be given by the Attorney General's chambers. Good governance demands that such legal advice is provided. The Governor, Premier, and ministers rely on legal advice of the Attorney General's chambers. Madam Speaker, it is the legal advice of the Attorney General chambers on which Cabinet acted that brought into question the application of the 688 persons that we are now seeking to validate today so that they are not disenfranchised for no fault of their own. It is very important to state, Madam Speaker, that with the exception of this legal requirement which was missed by the Attorney General chambers, all of the application qualified based on the law, except for one individual. In the Auditor General's own words, she says in the addendum, all applications approved under the program, save one, would have met the 7-year requirement and thus be valid. Even the one person identified as having applied after 6 years has been in the BVI for a total of 35 years. Madam Speaker, that one person has been in the territory for 35 years. The individual was in the BVI between 1981 and 2006. For whatever reason, the person did not receive their status, and they returned in 2020, and they applied and received it in 2019. Madam Speaker, as I have already said, the Attorney General chambers made an honest oversight in the legal advice provided to Cabinet. I can understand how they overlook this critical aspect of the law, because the chambers are under-resourced and overworked. This is why the Minister of Finance approved additional resources for the Attorney General's chambers since becoming the Premier on May 5th, 2022. The Attorney General has to have the adequate manpower to provide accurate and timely legal advice to the government. Madam Speaker, I have noted the deliberate public attempt in some quarters to unfairly assign blame on this issue. Clearly, when information was recently brought to light, the facts were deliberately left out. While I understand it is a campaign season, it is with great disservice to the public to spread such information just to seek to discredit persons running for office. It seems some will spare no doubt in doing so, even if it means hurting the innocent loved ones of persons even in this honorable house. Madam Speaker, they have gone as far as to falsely spread rumors that the spouses of certain honorable members who applied to the fast track program did not qualify for belonger status, but that this was still granted to them. Madam Speaker, this is absolutely not so. Let me be perfectly clear. Honorable Neville Smith's wife was married to him for 5 years and qualified based under Section 16(6) of the law. Honorable Shari DeCastro's significant other satisfied the requirement for years required under Section 16(4), and the Premier's wife by far satisfied the requirement of years required under the same section. When Cabinet approved applications, he recused himself and did not vote. Furthermore, Honorable DeCastro and Honorable Smith were not a part of Cabinet at that time, but yet those who are spreading the misinformation, they conveniently left that out to sway public opinion. Trying to unfairly present someone as corrupt for their own personal gain is not the right thing to do. And it is even lower to use the lives of the 688 people as a political football, because they are nothing more to you than collateral damage in a political game or quest for such power. Madam Speaker, for anyone that is in doubt about the facts, I encourage them to read the Fast Track Audit Report and its addendum, and there you will have all the facts at your fingertips. Madam Speaker, to the 688 qualified persons whose applications we are seeking to validate today, I say to you, you have done nothing wrong. You applied, you paid your fee, you did what was required of you. You have a legitimate expectation to be treated fairly. I do not agree with those persons who argue that we should deny you the opportunity to vote. They say you should just wait and sit this one out. Let's just sort it out a bit later. Madam Speaker, that would be wrong, immorally wrong, and an act of disenfranchisement of the members of our community. The Governor and the Premier are in full agreement on this point. Rectifying this issue has to be dealt with now. The 688 individuals are not mistakes as some has characterized them. They are hard-working people who have contributed to the success of these Virgin Islands. Many of them are very excited to be part of the democratic process, and they should not be disenfranchised. Madam Speaker, let us see these 688 persons not just as voters. Let us take the politics out of it. They are contributing members to our society. They are members of our community. They are our brothers and sisters who we must treat with the dignity and respect and show love. Their lives and their families should not be used in such personal vendetta against this government or anyone else. An individual's immigration status has fundamentally important consequences for each person, weighed by their ability to vote. It can affect the rights and liabilities of an individual and his or her family in many ways, including in relation to matters of succession, inheritance, the liability to taxation, amongst other things. It is our legal and moral duty and responsibility to rectify the situation, and that is what we seek to do today. Madam Speaker, colleagues, let's put aside politics. In the words of the great Martin Luther King Jr., the time is always right to do what is right. The Attorney General's chambers have drafted a bill and advised that this will solve the outstanding issue by ensuring the Belongor certificates received by the 688 persons are validated. I'm comfortable that they have studied the issue carefully, and I have confidence in their conclusions. I ask all members present, Madam Speaker, to support this bill. Madam Speaker, looking ahead, we need a long-term solution to our immigration challenges so we do not find ourselves continuously doing fast-track programs. A review on immigration has commenced. The public must be consulted on what they wish to see. A new immigration policy must then be developed and adopted, and the law will have to be amended to reflect that policy. In doing so, government will have to take into account the skills needed in our economy, the need to ensure locals continue to have employment opportunities, or carrying capacity as it pertains to our social, physical, health, and educational infrastructure. We must not be afraid to do what other governments fail to do.